Everyone kindly turn off your microphones and videos. We are starting. Thank you so much. In the words of K. Shanmugam, and I quote, the Singapore Convention on Mediation is the missing piece in the international dispute resolution enforcement framework. It will help enhance the cross-border enforceability of mediated settlement, and business will benefit from greater certainty and assurance. So with this, I would like to welcome you all to the international webinar on Singapore Convention. I, Malika, will be the moderator for the day, and it's my pleasure to have you all with us. Mediate Guru is a pan-India initiative with a community of professionals from across the globe. The organization has an inquisitive nature as to understand the problem and provide a redeemable solution. The aim of the organization is to bridge the gap between general public and litigation. Here our organization comes into picture. We are creating a social awareness campaign for showcasing mediation as a future of alternative dispute resolution to provide ease to judiciary as well as to the pockets of general litigants. The Singapore Convention on Mediation is a uniform and efficient framework for enforcing the international settlement agreements resulting from mediation. It applies to all the international settlement agreements resulting from mediation concluded by both the parties to resolve a commercial dispute. In 2019, India was amongst the first group to sign the convention. I would like to welcome the speaker of the day, Ms. Anna Sambold. Ma'am is one of the leading alternative dispute resolution professionals in the United States. She is an IMI certified mediator and international arbitral woman. Also, adjunct professor of law for the California Western Law School International LLM program. She received her Master of Law from University of San Diego School of Law and her training and credentials in dispute resolution from Harvard Law School, Pepperdine University School of Law, Strauss Institute for Dispute Resolution, Chartered Institute of Arbitrators, and Columbia Law School. Ma'am, we welcome you. Please start the session and take it further.
Well, good morning, everyone. It's 8 a.m. here in San Diego, California. I guess we have people from all over the world, so good afternoon and good evening too. I'm delighted to be here today to talk about the Singapore Convention, and I truly believe it's going to be very beneficial for international trade and for stakeholders, for users of mediation, and for mediation itself. So before we start, let me go ahead and share my PowerPoint. So present. Malika, so I'm supposed to start to share my screen. I go to present now, right?
Yes, ma'am. Yes, ma'am.
And I choose the entire screen, right?
Ma'am, you can choose present windows. There will be an option.
Okay, present windows. A window. There we go. There we go. Everybody can see it? Malika?
Yes, ma'am.
Okay, perfect. Good, great. Well, so yeah, I'm a mediator, an attorney, and an ADR professional here in California, and the biggest advocate for mediation. And that's what I love to talk about the Singapore Convention, because, like I said, it's going to be very beneficial and it's going to bring many benefits to the whole world. So, but before we start, let me give you an agenda about what I'm going to cover today. So, in the beginning, I would like to give you an overview of the difference between all the ADR mechanisms. And then I will give you a background of the Singapore Convention. And then I will provide you a general overview of the main provisions of this convention. And I finally will talk about the practical effects and opportunities that this convention is going to bring to everyone. So we have different alternative dispute resolution mechanisms, and basically the difference between all of them, they're very different, but what they all have in common is that they are different ways to resolve conflict out of court, that they don't require litigation. So the main types of ADR, of alternative dispute resolution modes of forms, are negotiation, mediation, and arbitration. So in negotiation, basically we have the parties directly, the parties involved in a dispute, trying to resolve the dispute directly without the need of a third party. But when we talk about arbitration, an arbitration is a process similar to an informal trial where an impartial third party, the arbitrator, hears each side of the dispute, reviews the evidence, and renders a decision called the arbitration award. So the arbitrator is basically a private judge. Most arbitrations result from contracts which provide that future disputes will be resolved by arbitration. This arbitration clause provides the major terms for the arbitration process. What will be the number of arbitrators, the arbitration forum, the arbitration rules. It is going to be binding or no binding decision, the fees, etc. But the thing is, arbitration is an adversarial process, just like litigation. So it resembles a simplified version of a trial, involving just limited discovery and simplified rules of evidence. But when we talk about mediation, unlike litigation and arbitration, is a collaborative and flexible and informal ADR process. So mediators are normally individuals that are trained in negotiations and conflict resolution, who bring opposing parties together in an attempt to work out an agreement. So mediators don't have the power to impose a solution, and that's the main difference with arbitration and litigation. The mediators are simple a third-party facilitator that helps the two parties in dispute to work out some type of deal or reach an agreement. The good thing about mediation too is that can be used for all type of cases, pretty much. You can mediate a divorce case, a commercial case. Here in California, we use it sometimes for juvenile cases. That is called restorative justice. There's some type of mediation that is used to address minor crimes committed between the person that perpetrated the crime and the victim. So that is one of the greatest things about mediation, that it can be used to resolve any type of dispute, pretty much any type. But let's talk about arbitration and mediation in the international commercial field. Because to understand why we ended up with the Singapore Convention, it's important to talk about the role of mediation in the global system of international commercial disputes. Well, mediation has now had a major role in the international commercial field. In cross-border commercial transactions, international arbitration has been the preferred dispute resolution mechanism. And in fact, the vast majority of international commercial contracts always mandate arbitration in the event of a dispute. Why is that? Well, parties to an international contract dispute have been reluctant to choose mediation due to two primary reasons. First, a settlement agreement resulting from a mediation provides no finality. Aside from cases where a mediated agreement happens in the context of a pending arbitration, where the mediated agreement can be converted into an arbitral award, this mediated agreement is essentially a private contract with no additional legal status or transnational privilege. In consequence, parties can only enforce it in the same way as in any other private contract. So that means going to court. So just think about it for a minute. Visualize two people are in they're in dispute over a breach contract. They try to go to mediation, and in mediation they reach an agreement. That agreement is basically breached by one of the parties. So what are the options for well, that party will have to go back to court to enforce the breach agreement resulting from the mediation, to enforce the agreement that was breached in the first place. So the party ended up with two breach agreements and ended up in litigation again. So the second benefit, or the second reason why mediation is not commonly used, has to do with the fact that mediations of international mediations don't have a legal regime for the efficient enforcement of mediated agreements across different jurisdictions, just like the New York Convention for Arbitral Awards. So let me talk about the New York Convention for Arbitral Awards, and that way you know what I'm talking about. So this New York Convention, it was an international treaty that was adopted in 1958 and went into effect in 1959. So after 10 years, 32 countries signed or ratified this treaty, and today 164 state countries have signed it and ratified it. So pretty much 80% of the countries in the world have signed the New York Convention. But what is this New York Convention so important, and what is this about? Well, this convention is probably one of the most important and successful treaties in international trade law, and is largely responsible for the prevalence of international arbitration as a dispute resolution mechanism across the globe. Why? Well, basically, this treaty requires contracting states to recognize and enforce arbitral awards as domestic awards by converting them into a judgment enforceable by a national court. So, if two parties from different countries they go to an international arbitration, and the arbitrator renders an arbitral award, any of the parties can enforce that arbitral award, and all these contracting states, and as long as the contracting state with the debtor or the person of the party of the arbitration has the assets is a party of the New York Convention, the contracting state will recognize and will enforce that arbitral award just as a domestic judgment. So, and that's why arbitration and international arbitration become the number one system of form to resolve disputes at an international commercial field because of the New York Convention. And the fact that nowadays, after pretty much 60 years, we have 80% of the countries in the world being contracting states of being part of this international treaty, that gives the parties in disputes the reassurance that the arbitral award will be enforced everywhere, pretty much. So another factor that was in the background of the Singapore Convention I believe was the Global Pound Conference. And the Global Pound Conference was a great, unique project which main objective was to find out how civil and commercial disputes should be resolved in the 21st century, but concentrating on the needs of corporate users and dispute resolution professionals. So this conference brought together over 4,000 people from across the globe and in 28 conferences and in 24 countries. I participated in one of the conferences in Los Angeles, and I understand that Singapore was the one that held the inaugural conference. But the main key findings that they were identified from the extensive data collected during these conferences were the following four findings. First, efficiency. That's why corporate users, and that's why people in the 21st century want in their dispute process. They want efficiency. Besides that, parties expect great collaboration from advisors in dispute resolution. So corporations and companies, they expect their in-house counsel and out-house and counsel to collaborate with each other and trying to find ways to resolve their disputes in an efficient way. And the third finding was related to the global interest in the use of pre-dispute protocols on like mediation and arbitration, because those are two combined dispute resolution types. And the fourth finding of the Global Pound Conference series was that that people had a preference to use mediation for resolving dispute resolution, for dispute resolution and international field, and especially in the commercial field. And so wider use of mediation was preferred. And just to navigate with the difference between different legal systems and different cultures. So in conclusion, so the Global Pound Conference series and all the delegates from Asia, from Africa, from the Middle East, from the Americas, from everywhere, they all reveal a desire for legislation or a convention to promote the recognition and enforcement of mediated agreements across different jurisdictions. And that's why in 2015, the U.S. State Department brought up a proposal to the United Nations Commission on International Trade Law, UNCITRAL, to start working on a treaty, on drafting an international treaty to promote the enforcement and to provide a legal framework for the efficient enforcement of mediation agreements resulting from international commercial disputes and mediations. So the UNCITRAL, that is basically the United Nations Commission on International Trade Law, that is the core legal body of the United Nations in the field of international trade law, and that its mandate is basically to remove legal obstacles to international trade by progressively modernizing and harmonizing trade law, they start working on drafting this international treaty. And they created a working group number 2. So this working group, with participation of 85 countries, start working on the drafting, and after 3 years and many meetings of this working group, they finally, the United Nations General Assembly finally adopted by consensus the United Nations Convention of International Settlement Agreements resulting from mediation, and recommended that the convention be known as the Singapore Convention on Mediation, or Singapore Convention. And they recommended that it would be open for signature on August 7, 2019 in Singapore. So what? Let's go dive deeper into the main provisions of the Singapore Convention. So the scope and application. What the convention, the International Singapore Convention applies to? Well, the scope is very narrow. It just applies to international settlement agreements resulting from mediation. So if two companies, they're in different countries, they have a dispute and they resolve the dispute directly. For example, is international and is a settlement agreement. But in this case, because they resolve it directly without the need to go to mediation, that settlement agreement will be covered under the Singapore Convention, just because these parties, these two companies, didn't go to mediation. So remember, the Singapore Mediation Convention is applicable only to international settlement agreements resulting from mediation. Those three elements had to be part or had to be present for the Singapore Convention to apply. And what the convention excludes? Well, the convention excludes settlement agreements which had been concluded or approved in the course of a court proceeding or concluded for personal, family, or household purposes of family, inheritance, of employment law, and or are enforceable as a judgment or are enforceable as an arbitral award. And let me tell you why they provided that exclusion or why they excluded the arbitral awards. Well, is in many jurisdictions, they realize, the drafters of the convention, they realize that many jurisdictions, like California, for example, they have already many ways to enforce international mediated agreements, since like the California International Arbitration and Conciliation Act, SIACA. And the section 1297 of this act in California was treating a mediated agreement to international commercial dispute just as if it were a final arbitral award for enforcement purposes. This will apply even if no arbitration proceeding have been taking place, so long as the mediation occur in California. The whole reason of this provision in this Californian Act was because California realized that there was no treaty that would protect any mediation agreement or that it would make it enforceable across different jurisdictions. So a way to go around was to treat those international mediated agreements just as an arbitral award, and that way they will be covered under the New York Convention, because remember, the New York Convention just applies to arbitral awards reached in an international arbitration or render in an international arbitration. So the Singapore Convention drafters, they knew about that. They knew about these jurisdictions and the way that, for example, California was treating already international mediation agreements. And I know that other jurisdictions like Texas, Ohio, North Carolina, and Oregon, different states in the U.S., were doing the same thing that Texas. And at an international level, I know that a handful of countries, they were treating mediation agreements like an arbitral award for enforcement purposes. And I understand that India was one of them under the India Arbitration and Conciliation Ordinance. But what is the core of the Singapore Convention? Well, the main provision of the Singapore Convention is Article 3. And Article 3 basically provides that each party or each country that signs the convention basically are obligating themselves to enforce a settlement agreement in accordance with its rules and procedures. So basically, is acknowledging that every country must probably have different ways to enforce mediation agreements. So they let in every country and every state that signs the Singapore Convention enforce the settlement agreement in accordance with its own rules and procedures. And another interesting fact and provision from the Singapore Convention is Article 3.2 of the Singapore Convention that basically creates a shield or a defensive shield and allows the party to invoke a settlement agreement to prevent a dissatisfied counterparty to the agreement from later litigating a matter that was already resolved by mediation. So the drafters understood this to be a complete defense and no just rule to admit the agreement into evidence. So in consequence, under the Singapore Convention, parties to a mediated agreement can have confidence that they won't have to relitigate an issue if a party refuses to comply or tries to drag the dispute back into court. Because the country will say, no, this dispute was already resolved in mediation. They're bringing me here the mediation agreement. So you can litigate this case anymore. And this provision is basically Article 3 of the main core of the Singapore Convention is basically the same, or basically mirroring what Article 3 of the New York Convention provides, because the only difference is the New York Convention
Hey, you wanted to mute. You have to unmute yourself.
Anna, ma'am? Excuse me, ma'am? Ma'am, your microphone is muted. Yes, ma'am. That's fine.
Okay, there we go. So let's go back to my presentation.
Yes, ma'am. It's visible.
It is?
Yes, ma'am.
Oh, I can see it. Could you see it, Malika?
Yes, ma'am.
Perfect. Okay, so let's go ahead and continue with the main provisions of the Singapore Convention. So the convention provides a definition for what is mediation. And the good thing is that is recognizing that different terms may be used around the world to refer to mediation. For example, in California, just like I showed you before, sometimes they refer to mediation, we refer to mediation as a conciliation. And I'm pretty sure in many countries in the world, they refer to mediation in different ways. So what the Singapore Convention tried to do was to define the process, and they define it in this way. They say, irrespective of the expression used or the basis upon which the process is carried out, whereby the parties attempt to reach an amicable settlement of their dispute with the assistance of a third person or persons, the mediator. But basically, mediation, it will be a process where the mediator lacks the authority to impose a solution upon the parties to the dispute. The whole point of defining the mediation in that way is to make it very clear that if the mediator or the third party that is helping the parties in dispute to resolve their dispute, it has the authority to settle the dispute, that is no mediation, and it won't be covered under the Singapore Convention. That will be an arbitration, and it will have to be covered under the New York Convention. And I think so that is excellent that the Singapore Convention just defined mediation in that way and made it very clear. So what are the convention enforcement requirements? Well, to ensure that an eventual agreement reached in an international mediation is enforceable under the Singapore Convention, a party to the dispute or to the mediation must provide the competent authority of the country that is party to the Singapore Convention the following. First, they have to provide the settlement agreement signed by the parties. Second, they have to provide evidence that the settlement agreement resulted from the mediation, such as the mediator's signature on the settlement agreement or a document signed by the mediator indicating that the mediation was carried out, or an attestation by the institution that administered that mediation, or, in the absence of one and two, any other evidence acceptable to the competent authority. In that way, if a party seeking enforcement shows all these items, the country and that where these items are presented, it will have to enforce the mediated agreement. Remember, as long as it's a party to the Singapore Convention and as long as it's an international mediated agreement resulting from mediation. So, what are the grounds for refusing to grant relief? Or why a country can refuse to grant relief and enforce a mediated agreement resulting from an international mediation and from parties that are signatory to the Singapore Convention? Well, a country may refuse to grant relief if proof is provided that a party to the settlement agreement was under some incapacity, or the settlement agreement is null and void, or inoperative, or incapable of being performed under the law to which the parties have validly subjected it, or is not binding or is not final according to its terms, or has been subsequently modified, or the obligations in the settlement agreement have been performed or are not clear, or granting relief will be contrary to the terms of the settlement agreement. All these grounds for refusing to grant relief are provided in Article 5 of the Singapore Convention. And here we will have more grounds for refusing enforcement that are basically related to the mediator, because another ground for refusing to grant relief is if a party can provide proof that there was a serious breach by the mediator or standards applicable to the mediator or the mediation, without which breach that party will not have entered into the settlement agreement, or there was a failure by the mediator to disclose to the parties circumstances that raised doubts as to the mediator's impartiality of independence. And that's probably one of the most controversial provisions of the Singapore Convention, because it basically is related to the mediator and serious breach of the standards. And there is a concern that the standards for mediators can be very different around the world. So my response to that concern is that we just need to work on proactively to develop a uniform standard system that provides a uniform standards for all mediators around the world. And that way it will be easy to rely on, and it will be consistent everywhere in the world. But let me talk about the Singapore Convention, the signing ceremony and conference. Because to commemorate the signing of the convention, Singapore hosted a week full of events from August 2nd to August 9 in 2019, and it was an excellent host. I was lucky and I was honored to be invited by the Singapore Convention to participate at the signing ceremony and the conference. And it was amazing to see hundreds of government officials, business executives, legal practitioners, and academics from around the world, all gathered together to witness the signing of this convention and participate in different events through the week, all related to international trade and dispute resolution. So, and it was very exciting, and you can feel the excitement at the Shangri-La Hotel where the signing ceremony was taking place. And here's a picture of the signing ceremony, and it was pretty consistent with what you feel when you are in a concert, when it's something very, very exciting. When you feel like, and I was amazed that an international treaty and the signing of an international treaty or a legal document will be so exciting and amazing. But here is the Singapore Prime Minister, and then each country was called to sign to the signing table. And here we have all the 46 states that signed the convention on the opening day, and making it one of the most successful conventions developed by the United Nations Commission of International Trade Law, UNCITRAL, so far in terms of signatures obtained in opening date. And because the fact that 46 countries signed it the first day is amazing. And if we compare, for example, with the New York Convention that was signed by only 10 countries on opening day, and after 10 years it was ratified by 32 countries. So let me show you what are the first 46 signatories to the convention. And we have India here, and we have China and the United States, and many countries from Latin America and Asia and Middle East and the Americas. And then we have 5 new signatories where Armenia, Chad, Ecuador, Gabon, Guinea, Bissau, and then so now we have, and then we have Rwanda signed the Singapore Convention on Mediation on February 28 of 2020. So now there's a total of 52 signatories to the Singapore Convention. I was personally disappointed that many countries that they were part of the working group from the UNCITRAL working group, many European countries, they were no part. They didn't sign the convention. And what I understood was that at that point they were trying to figure out if each country in the European Union needed to sign the convention, or the whole European Union as a bloc needed to sign it. So they were trying to figure that out, how to do it, and that's why none of the European Union countries haven't signed it so far. England haven't signed it either, and at that point, I guess they were very busy with Brexit. And other countries that are missing from signing the convention are Canada, Australia, Brazil, Argentina. Those are the ones that I can see, and you can see here in the map, you can get a pretty good idea which countries have signed, which countries have ratified, and which countries haven't done neither. So now, what is next? Well, the convention will enter into force 6 months after 3 states have acceded or ratified the convention. And the good thing is that from the 52 countries that have signed, 4 already have ratified the convention: Singapore, Fiji, Qatar, and Saudi Arabia. So now the convention will enter into force in September 2020. So what we need to do now? Well, we need to get as more countries to sign and ratify it, and that way we can start promoting and just helping countries around the world to become part of it. But how? Well, basically promoting it and educating the public, educating all the government officials, law students, lawyers, mediators. We have to tell them about the Singapore Convention and what implies, what entails, and what is the benefit that it's going to bring. And we need to get the support of business people, policymakers, and end users. And we have to ask transactional lawyers and corporations and companies to start incorporating mediation clauses and ADR clauses in their provisions and in their contracts. In that way, if they have a dispute, they will have to go through mediation, and hopefully we start promoting the use of mediation. And if the New York Convention is any proof, I'm pretty confident that the Singapore Convention will do to mediation what the New York Convention did for arbitration, and it was making it the most common and the prevalent way to resolve disputes in international field. And I'm pretty sure the Singapore Convention will do the same thing for mediation. It will promote mediation, and it will bring some assurance to people that the mediation agreements will be enforced on everywhere. But we need more countries to sign it. In that way, just like in the New York Convention, we will have at some point 80% at least of the countries in the world being participating and abide by the Singapore Convention. Because in general, the benefits for the global system are huge. The convention will be an instrument that will facilitate international trade, and it will provide some harmony and certainty and stability to the whole international framework of international trade. And it will be a huge step in encouraging the use of mediation of an international level, promoting it as an additional and the prevalent alternative to resolve disputes next to arbitration and litigation. And I'm very involved with the American Bar Association, and the American Bar Association House of Delegates, they developed a resolution to urge all nations and all the countries in the world, including the United States, to become party to and implement the United Nations Convention of International Agreements resulting from mediation, or the Singapore Convention. And this resolution was released on February 17, 2020, and we're hoping that United States ratify the Singapore Convention. They already signed it, but we need to ratify it, and is in the process of being ratified. And I guess because of COVID-19 and because the government has a lot and to handle right now, they haven't formalized the process of ratification, but I'm pretty sure by the end of this year, I'm confident and I'm hopeful that the convention will be ratified by United States by the end of this year. And why I love and I love to talk about the Singapore Convention? Well, because I think that mediation is by itself and on the regular and normal situation is collaborative. It promotes understanding. It is not an adversarial way to resolve disputes. And I think and I believe that now more than ever, with our current situation, with COVID-19, with a health crisis, with civil unrest, with all the racial tension that is going around the world, now more than ever, we need to promote mediation. We need to promote understanding. We need to promote a collaborative, non-adversarial way to resolve disputes. And we need to promote communication and conflict resolution. And I think so mediation is the best way. And the good thing is mediation can be done online. I've been doing a lot of mediations online by Zoom lately. That I'm in a lockdown. California has been in lockdown for the last 3 months, and we have a small window of 2 weeks when we reopen, and now we're back in lockdown. So I keep doing my mediations online, and this is the wonderful thing about mediation. You can do it online. And this is a picture of me 2 weeks ago when we reopened for a little bit and we had to wear a mask. Well, I didn't care that I had to wear a mask for 7 hours. I just wanted to help parties to resolve their dispute, and we did it. And that's what I want everyone to be inspired and to embrace. And hopefully all of you who are watching this webinar, that I assume that you're watching it because you want to know more about mediation, you want to know more of the Singapore Convention, so you're probably interested and you love mediation. So please go out there and spread the word about mediation, promote the benefits of mediation, promote the value of mediation. If you want me to talk about mediation, just let me know, and I will go and I will come to your group and I will explain, and I will just present and repeat my presentation. And because at the end, and that this quote that I want to show you, I think so it encapsulates and what is the value of mediation. And an ounce of mediation is worth a pound of arbitration and a ton of litigation. And I love that quote because it basically encapsulates what is the value and what is the power of mediation. And I hope all of you, like I said, become ambassadors of mediation and promote mediation everywhere in the world. If you have you need more information about the Singapore Convention or mediation in general, please don't hesitate to contact me. If you want me to talk to your group about it, I will be happy to. This is my contact information, and all the way in California, but nowadays we can do everything online. So I'm happy to help. And with that said, I guess I'm ready to take any questions.
So ma'am, we can now move towards the interactive session of question and answer. So,
Perfect.
We have 8 questions planned, so you will ask one by one and you can answer them.
Okay.
Ma'am, the first question is, what regulation of mediation by way of statutes and conventions, etc., take away the flexibility and the essence of its practice?
Well, I guess the question, the person that made that question, they were worried that the Singapore Convention would take away flexibility from the mediation practice. Well, you don't have to worry. The Singapore Convention, like I explained during my presentation, is pretty flexible and it doesn't impose anything specific to mediation practitioners around the world. The Singapore Convention is basically only legal framework that will facilitate the enforcement of mediated agreements across jurisdictions. It doesn't touch and it wouldn't impose any requirements, or it wouldn't impinge on the flexibility of the mediation process. Malika, you're mute. You're mute.
The second question is, how is Singapore Convention different from Geneva Convention and New York Convention?
Okay, first of all, the Singapore Convention is related to mediation, international mediated agreements, and it's about enforcement, and it's about basically mediation. The New York Convention, as I mentioned, is about international arbitral awards. It's basically about arbitration. The Geneva Convention is about war crimes and protecting soldiers during war. So it doesn't have anything to do with ADR or with mediation or arbitration. It's just another international treaty, but it doesn't have anything to do with ADR.
The third question is, uncertainties in operationalization of the Singapore Convention.
Okay, well, I will say that the uncertainty is, first of all, how many countries will sign it? Because if we have, the more countries that we have, the more effective it will be. Just like the New York Convention that now has 164 countries around the world be contracting states, that makes it more likely if a party gets into an goes to arbitration and they get an arbitral award in this international arbitration, is more likely that the party is from a country that has been part of the New York Convention. So the main uncertainty that I see with the Singapore Convention is that we don't know yet how many countries are going to sign it. Hopefully many, and we will just implement it along the way. But I believe that the New York Convention, it was a good example and is a good role model to follow. We have the New York Convention to work out on the details and uncertainties that we have with the Singapore Convention.
The next question is, how to address the arbitration issues related to companies based in two different countries under central regulation of those parent countries.
Okay, let me see how to address the arbitration issues related to companies based in two different countries under central regulation of those parting countries. Okay, so this person is asking about arbitration, international arbitration. Well, when you have an international arbitration, as I mentioned, they normally have an international arbitration provision in their contract, and the arbitration clause, they will provide the forum, they provide the law that will apply, they provide all the rules of the arbitration. And so the arbitration clause will provide for all these issues, and it will provide all the rules of the process. That's how arbitration normally works, according to the rules provided in the arbitration clause provided in the contract.
The fifth question is how to address arbitration when two parties are governed by the regulations of two separate countries having a common interest in the subject of arbitration.
Okay, so let's repeat the question. How to address arbitration when two parties are governed by regulations of two separate countries having a common interest in the subject of arbitration? Well, I believe this question is pretty much the same thing that the previous question, and I can answer in the same way. Two parties that are in different countries, and they ended up in an arbitration of bringing their dispute to arbitration. Well, they will probably bring the arbitration. They bring the arbitration, the dispute to the arbitration proceeding is because they have an arbitration clause in their contract that mandated the parties to go to arbitration. And just like I said, that arbitration clause normally provides all the rules of the process. What will be the institution administering the arbitration, how many arbitrators they want, the form for the arbitration, everything. It will provide everything.
Thank you so much, ma'am. As all the good things come to an end, so has this session. I would like to thank ma'am for such an enlightening and informative session. I would also like to thank all the professionals from different parts of the globe who joined us today and made this event a success. Thank you so much. I hope all of you have filled the form, which we have sent the link. It will be activated only for 20 minutes.
Perfect. Thank you so much, everyone.
Thank you, ma'am. Thank you so much. Bye.
Thank you so much.
Ma'am, someone is asking for your details.
Feel free to send them my email.
Okay.
You want me to type it or? Let me see if I figure this out.
Thank you very much. This session is very nice.
Yes, the students can leave now. We will send you ma'am's email.
They can contact me through LinkedIn too.
Yes, ma'am. Thank you so much, everybody. The attendance link is in the chat box.
LinkedIn is the best. Yes, that's right. That's how you guys found me, right?
Yes, ma'am.
Oh, did I stop sharing my screen? Or still you can still see it?
Yes, ma'am.
You want me to stop sharing?
Ma'am, we cannot see the screen.
Oh, we're fine. Okay, good. I love your background, Malika.
Thank you so much. So all the students can leave now. The session is over. Thank you so much for joining.
Thank you very much, ma'am. This session is very nice.